Hi everyone, thank you for joining us for another episode of Professors in Conversation. Today we have Professor Procaccini joining us. She teaches civil procedures to the 1L students, Constitutional Law 2, and a seminar on judicial review. Professor Procaccini, thank you for joining us today.
Thank you, it's wonderful to be here.
Today we're here to talk about free speech, social media, and AI and algorithms.
Yes.
And before we kind of jump into those topics, I want to start with the foundational question. What is the First Amendment? What does it protect? And how is speech implicated?
Okay, great. So, simple question with actually not a simple answer. So let's break it down. What speech does the First Amendment protect? There's going to be two questions there. What is speech, and how does the Constitution protect it? On the what is speech question, it's a little tricky, but for the most part, we're going to say we're going to be very broad with our definition of speech when it comes to First Amendment protection. Lots of things are going to be speech. Things, obviously we are speaking, that is speech. But we're also going to include symbolic speech. So if I'm waving a flag and I meant to be communicating something by waving that flag, that is going to be considered speech. If I'm donating to a candidate, right, that is my political speech. So my campaign contribution is going to be considered speech. Art, entertainment, all of the above, right? We're going to consider all of this sort of expressive conduct speech. So that's a lot, which means we're going to have to calibrate constitutional protection accordingly. For the most part, speech gets a lot of constitutional protection. We want to be very vigilant about the government coming in and suppressing speech, because when you suppress speech, when a government suppresses speech, it really risks tilting honestly, the very course of society itself, right? So we give speech a lot of protection, but, and this is very key, and I think this is where sometimes, this is the point that sometimes we forget, especially for those of us not in law school yet, sometimes we forget this part. There's a lot of protection, but it's always contextual protection. It's always protection that is contoured to the situation. So if it's speech, if it's about speech that's happening in a park, no problem, it's protected, but you know what we're gonna say? It's not protected? Blaring music in that park at midnight when there are residences right around the park, right? So lots of protection for what you can go and say in that park, but not total protection. We're gonna make sure that that protection is contoured around what is necessary to maintain safe and effective and healthy speech environments. So that's like the most foundational level of what the First Amendment does. And then the trick is going to be, how do you apply that broad framework, right, into specific speech environments, including online environments, AI environments, etc.
All right, so let's talk about that a little bit. Technology is evolving very rapidly. Mm-hmm. How should courts and scholars approach these new speech contexts that don't fit neatly into existing doctrines that kind of courts and scholars have applied in the past?
Great. So this is a great question. So I think there's two steps to how we apply, the architecture of First Amendment doctrine to very rapidly evolving technologies. Step number one, we do a process of analogy. So this technology, yes, it's new, but it's got to resemble something. It's got to resemble some other context, some other speech context. And those contexts probably already have established First Amendment doctrine governing them. So we can borrow from these established contexts, or at least, even better, we could learn from them through analogy. So one thing I've done, and we can talk about this further, is I've made the argument that social media in particular is actually very analogous to speech in the workplace. And we can get into that. But the point of that, making that analogy, is to say that actually, so the First Amendment doctrine that governs protection of speech in a workplace might be really valuable to mine for rules that might be applicable or relevant, or beneficial to carry over into the social media context. Okay, that's step one, right? We do analogy. Step two is we don't stop there. We don't pretend that this technology is not new. And it is, as you said, it's a totally new beast. So we can't stop at analogy and just say, oh, it's like a train or it's like a workplace, and so we're just gonna, boom, pluck the law from those contexts and put them in social media. No, social media is different. And so the next step is a process of evolution, where we take the relevant analogies and we build from them and create a new First Amendment architecture that is, and I think this is what's key, that is sensitive to the unique harms that the new speech context is presenting. And the reality is that social media, but even more than social media, really just the advent of AI in our information streams, ChatGPT, to put it simply, are presenting newfound, different, unique harms to society, as well as newfound, unique benefits to society. And you need a doctrine that can address the harms while reaping the benefits. And that work is necessarily constructive work. And so that's step two.
Okay, now I want to focus on social media first.
Sure.
In one of your papers, you kind of cite to other analogies that have been used for social media.
Yeah.
There is the public utilities, consumer services, or informational services. Mm-hmm. What are some limitations on these existing analogies, and how does a kind of labor law work framework fit better for the social media context?
Great. So I think it goes back directly to what I just said. It's about the harm. So I think some of the limitations to the competing analogies for what social media is most like draw on some harms that social media present, but to me, maybe not the most important or actually the most prevalent harm that it presents. So for example, if we're thinking of social media more as like a public accommodation or a public utility, what we're really saying is that the harm that social media presents is maybe a harm about discrimination. Because when we think about access to, a store or to electricity, what do we care about there? We care about the fact that someone is not getting discriminatory or unequal access as opposed to someone else. Social media presents discrimination problems, but I think it presents much more profound problems than just ones of discrimination. Same thing with, for example, thinking of social media as like in a fiduciary sense. Well, that conceives of the harm of social media as one in which we're the company is maybe mishandling our data. Just like a fiduciary, like the harm we're worried about is that it would mishandle, right, your money or something like that. And that's a possible harm, and oftentimes that is a harm. But again, I think that harm falls short, or that understanding of social media falls short of really recognizing what the harms are. So in a labor framework, what do we worry about in terms of the laborer in a workplace? What kinds of harms is labor law trying to capture? Well, it's trying to capture health and safety harms, as well as dignitary harms. And to me, the harms presented by social media are actually much more health, safety, and dignitary. It is about the child going online and encountering information that is genuinely harmful to their development. And it is and so I see an analogy to child labor law there. That child labor law is trying to protect children from these exact same types of harms. When we think about labor law in terms of union organizing or labor rights, we are focused on making sure that just because you are the employee and not the employer, you still have rights to some sort of control and dignity in your workplace, some sort of ability to voice your say. And I think that that is really key in the social media context, where you have these social media company overlords, right, who are really dictating everything you can say or see, and that it's really important that we actually retain some control over our social media environment. So I think of the harms as mapping on, the harms on social media, the ones we really actually care about, as mapping on to the harms that we really actually care about in the workplace. And that labor law has done a pretty good job at addressing, even if it could always go further and be better. And so that's why I think that analogy at least needs to be a part of the puzzle to complement these other competing analogies that are focused on addressing other harms.
I really liked how you framed the relationship between users and the platforms as like an employer-employee relationship, because you cite this in your paper. These platforms are making a lot of money off of like the users' data by selling to advertisers. So I found that image of an employer-employee setting really profound. It just made sense in my head.
Yes. I know, and sometimes it's like you don't think, you're like, well, I'm just like scrolling through TikTok, and you're like, this is not work. In fact, I probably should be doing work instead of scrolling through TikTok. And what I try to do is reframe it and say, actually, when you are, that little scroll is actually a new form of labor for various reasons, and I make the analogy, and one of them being you are that little scroll, right, is actually your labor putting in, that is the thing that they are profiting off of. And so that profit connection is right there, direct.
I know that social media platforms now have AI intertwined with everything from advertising to whatever content they suggest to you. And so I kind of want to shift gears to your more recent publication. And in it, you talk about, I think you name it the new speech doctrine. And you kind of argue for, in order for these new speech doctrines to kind of be effective, it needs to protect informational and community functions, permit regulation that addresses extreme disparities, but also remain attentive to enforcement challenges that arise with these new contexts. Do these kind of principles provide a transferable framework for future technologies that may come up that we can't see or anticipate kind of coming on the market? Like, it seems to me that you argue for a need to kind of create a doctrine that's somewhat future-proof. So I was wondering if you can kind of talk to us a little bit more about that.
That's great. So I like how you put that, and I'm gonna, by way of answer, I'm gonna tweak it slightly.
Perfect.
I think what we need to do is create a method of creating doctrine that is future-proof, and that's actually the exact point. The doctrine itself. What do I mean by doctrine? Right, the rules for free speech protection. Right, the free speech rules that will apply in any given speech situation. Those rules must be capable of adapting, because free speech situations adapt with new technology. So I'm very much in favor of a method, a principled method for how to update doctrine that would be future-proof, that would allow the doctrine to update with future technologies. And this is kind of going back to the step one, step two. And you can think of it this way, right? If I said step one is sort of making sure that we don't just randomly update constitutional law too fast, right? We don't want it to be at the whim of whatever we think about a given technology on a given Tuesday. That's obviously not a good way to do constitutional law. So we always want to be mindful that we're taking incremental, slow steps, and that we are tethering, right, whatever we're doing in the future to future technologies to established doctrines, right? So that's that analogy point, that we want to make sure we're not just wholesale inventing something, because oftentimes the first time you invent something, it actually doesn't go too well, right? Okay. Now, but it's again to say that we don't want to stop at step two. So I can talk a little bit more about step two now, because that's the really important part for AI. AI is it's nothing we've ever seen before. It just is. It's the modern day printing press, in the sense that it's come on the scene, and get ready, it actually already has, revolutionized society and the way in which, when I say society, I mean the way in which information flows, is created. But by that, I mean the way in which we actually build relationships. So human connection is being revolutionized by AI, which means we have to have a constitutional law that's up to the task of doing the things that you said, of both protecting the potential of this amazing new technology, but being very cognizant of the harms it could wreak, and being able to permit government to regulate it in ways that are smart and in ways that are needed. And I'll use the printing press just one more time. The printing press was great, right? It democratized the spread of information and everything. It also caused many wars, like directly. It was also a very bloody invention at the end of the day. Religious wars, right? I mean, 100-year, there's two sides to any coin of an invention, like AI, and we want to prepare ourselves to try to avoid the worst of it and try to get the best of it. So to do that, we really need to, again, start from analogy, recognize the harms, but it would be a mistake, in my opinion, to say that somehow this technology, because it's new, just exists outside of a regulated space, just because we protect speech and we protect expression, and obviously this is within the domain of speech and expression. We need to be able to harness the technology, and a harness means an ability to control. And we need law, right? That's why you come to law school. You need law to navigate control.
That's awesome. Our professors are always working on something cool and amazing.
Always.
What are you working on right now?
Okay, this is great. So actually, I'll say a word about what I just ended on, which is, I said these AI technologies, right? It's obviously speech and expression. I snuck in the word obviously, I think, but it's not so obvious actually. And so I'm kind of working on actually that question. When we say, back to the very beginning, you said, what does the First Amendment protect? And I said, well, speech. And what is speech? I want to focus on that question. Why is AI in fact expression that should get some sort of constitutional solicitude? That is deeply underdeveloped. What is speech? I hemmed and hawed a little at the beginning, and I gave you some examples, but the reality is the lines and the limits in our understanding of what should be considered expression and not is deeply underdeveloped. And that point, we've been fine with that for a long time because we've been able to use intuition, but AI is challenging our intuitions of what is expression. So we need to do some real work on figuring out some principled limits around that, and that's my next fun, very nerdy project that I'm excited about. Hopefully others will be too.
Well, that's awesome. Well, Professor Procaccini, thank you for taking the time today to educate us on free speech, social media, and AI. And thank you to the viewers for tuning into another episode of Professors in Conversation. If you want to see more of these types of videos, subscribe to our YouTube channel. If you want to see other forms of content, follow us on TikTok and Instagram. Thank you.
Thank you.